Let's talk about what happens when someone dies. Generally, when a person passes away, they typically own something. Whether that asset is a bank account, a car, or real estate, the family will most likely need to probate the estate. I say most likely because probate may not always be required. So how do you know if you need to probate? The answer is in the assets and the debts. Well, what does that mean? Texas has a few different options for probate, depending on the type and the value of assets, and whether the person had a will when they died. Before you learn about each type of probate process available, you need to understand what probate is and why it is needed. First, let's learn some basic terms. When a person dies with a will, they are said to have died testate. If they did not have a will, they died intestate. So testate is with a will, and intestate, no will. The executor is the person in charge of the testate estate under the will. An administrator is the equivalent in an intestate estate without a will. And there are some nuances there, such as an administrator can be appointed under a will if the executor cannot serve and there's no alternate. But we're not going to go into all of those details in this video. Next is letters testamentary. This is a legal certificate issued by the court that names the person with the authority to act on behalf of the decedent in a testate estate. Letters of administration is the equivalent when the person died intestate. Decedent, of course, is the person who has passed away. So what is probate? Well, it's the formal process of presenting the estate to the court of jurisdiction and having someone appointed with the legal authority to gather assets and distribute the estate. So why is it necessary? Well, during a person's life, if you own certain assets and you choose to sell them, then you have to legally sign over title to the buyer. What happens when you die? Well, obviously you cannot sign title transfer documents. So how do you transfer the title to an asset that is owned by someone who's passed away? You have to have someone step into the shoes of the decedent. Now that person has the ability to transfer the assets. So let's take it a step further. Mom and dad own a house, children are grown, and they live miles away, and dad dies. Mom's health is declining, and there's been no probate process, and mom wants to sell the house to move closer to the kids. The title company won't let her sell without having all of the kids sign off on it. But wait, the house is hers, right? Did dad have a will? Did dad have children from prior relationships? Depending on the circumstances, if we probate the estate, an executor or administrator can sign a deed transferring the property to mom, or the executor or administrator could sell the house in the estate. Some assets can be transferred without going through probate, and there are some options when the only asset is real property and there's no outstanding debts. Every estate is different, so it's important to discuss the options with an experienced estate attorney. For more information about the types of probate available in Texas, be sure to check out our other videos. If you have questions or need information, please visit us online at www.rondahayneslaw.com or contact our office to schedule an appointment at the number listed on your screen. Don't forget to friend us on Facebook. We look forward to serving you.